Welcome to Meet the Candidates. I'm your host, Kim Kotis, and I'm here with Joe Bush, who's running for Muskegon County Probate Judge. Welcome, Joe.
Thanks, Kim.
So, Joe, tell us a little bit about your background and why you're running for Probate Judge.
Well, Kim, I've been an attorney for 20 years now, 18 plus years. I have actually over 20 years of trial experience. While in law school, I served at the Wayne County Prosecutor's Office for 2 years trying cases for them. And that's why I actually have more years of trial experience than I actually do as a licensed attorney, because under the court rules in Michigan, if you're a law student and you're in good standing, you can actually practice law under the direction of a prosecutor's office. So I've been trying cases for over 20 years now in family law and in probate, in business and real estate, and in criminal defense. So I've been in Muskegon for over 18 years. I'm originally born and raised here in Muskegon, moved back after school and started practicing law in a medium-sized firm, and am now a sole practitioner for the past 6 years.
So tell us a little bit about why the probate position is important to this community in terms of families and resolution of conflicts.
Well, probate court is interesting because there's concurrent jurisdiction. So the state court administrator and the head judge here can identify certain portions of the docket that can go to probate court or to circuit court. And here, what we're being told right now is that this will primarily be family court and probate, which dovetails well in the probate court, because probate court judges generally in probate court look out for the best interests of people. They protect individuals and families generally. And they do that in a number of different ways. There's guardianships and conservatorships for adults that are incapacitated, for people who are mentally ill. They may have commitment proceedings, involuntary, or work with them voluntarily. There may be guardianships for people who just can't, as adults, are incapacitated and are vulnerable adults, or children that need protection. So there are protective orders that can be put in place for people. And there are also conservatorships for their financial affairs to make sure that someone's in place to protect them financially if they have assets that need to be protected. And that dovetails a little bit with the circuit court. If people recover money from a settlement or from a personal injury case and they're a minor, they would need to protect their assets that way. Also in the family court, what we would have from a family court standpoint would be divorces, child custody, and protective proceedings for abuse and neglect. If there are children that need protection, their parents are in the process of going through issues and can't care for them properly and are not caring for them properly. There would also be cases, post-judgment proceedings in family court for divorce, such as child custody, parenting time, and child support as well. So,
could you talk a little bit about some of the procedures that happen pre-trial in terms of people understanding the case in front of you, as well as the, I'm taking that back again. I want to phrase this differently. Okay. Could you tell us a little bit about the processes that people will go through, some of the early proceedings in terms of trying to determine whether it will go to a trial before the judge, or some of these things can be settled in arbitration or other alternatives?
Sure, Kevin. The process, depending on what kind of matter you're dealing with, but in family court, for example, when someone files for a divorce, the issues before them are whether or not, primarily, if they have children, it's going to change things right off the bat. It's a different format. It's going to be a minimum of 6 months before the case can actually be even close to being finalized. Because of the children, our legislature has determined that we have a 6-month cooling off period. So what that means is we want a longer opportunity for the benefit of that family, that hopefully there's a chance that they can rectify the relationship, that it's not lost. And that gives them a little bit more time. So hopefully in the course of that minimum of 6 months, that everybody cools off. Maybe there's counseling, maybe there's an opportunity to get things resolved and amicably and come back together as a family unit. So one of the things that happens when you file a case like that is there's an immediate conciliation conference. And what that means is that the parties go and sit with the friend of the court. They identify how they want to move forward in the temporary term of that 6 months, or until there's a trial or there's a judgment entered by consent. How are they going to manage their lives? How are they living now? Are they living together or apart? Do they have adequate childcare if they are both working? Or is one parent at home and they're going to primarily be providing care for minor children? So the other aspect of that is financial. How are we going to set child support if there's a need for it between these two people while they're contemplating dividing all of their assets and dividing up their family? So it's important to recognize that that is what happens right off the bat, and that's done without lawyers. So once the parties conduct that conciliation with the friend of the court, a proposed recommendation goes to the court, and if no one objects to that within the time period given under the statute, then an order gets entered, and it's a temporary order until there's a further order, which would happen by consent or by a judgment being entered at the end of the case. So that's kind of how a divorce case starts in the family court. And from there, once lawyers are involved, if they're involved, there's a number of different things that can happen, but typically there's a discovery period where people learn about assets, reasons for the divorce. In Michigan, while it's a no-fault state in terms of divorce, and what that means is you don't have to give necessarily a reason. Nobody has to be at fault. However, if the court does find fault, it can tilt the scales financially. And typically that doesn't happen very much. If it does, it's by usually the max 10%. I've seen it happen usually in the 5% area, but for the majority of cases, fault isn't really an issue. And in looking in fairness, every case is different. Usually there's some fault lying on both sides anyway. In the relationship area, if it's going to dissolve, usually both parties have some culpability. So, but every case is different, and that's the judge's job, if the lawyers are going to present facts on that, to be the arbiter and to decide if there is fault.
Well, can the court decide or recommend people go through either any other kind of screening or therapy or some other ways of trying to resolve their personal problems instead of necessarily going for a divorce? Because maybe people just haven't found a way to get along and they need to resolve some of those.
Well, judges can't force or compel someone to go through therapy. As a lawyer, when I handle a divorce case, I always recommend that my clients go through therapy. If they have minor children, especially young children, I typically won't file a case unless they've made some effort to do that, because I believe that I want to protect families and that people sometimes need to look inward, and it's a good opportunity for them to do that first before they just run to court. Because once you do that, the clock's ticking, and it's a better opportunity to heal things first before you start trying to end things. So from a practical standpoint with the court, though, the judges can't compel that. What they can do, though, is they can order under the ADR rules in Michigan, they can order a facilitated mediation. They can order the parties to go sit down with an attorney that's been trained or with a licensed facilitator that's recognized by the court to sit down and go through what issues they have. Usually that ends up being, for the most part, issues on parenting time, spousal support, custody of the children, and division of property, the property, their assets that they're going to divide up. There are times, however, where in certain cases, parties have gotten together in a facilitated mediation and the light bulb has come on. And talking through that without their own lawyer, but with a mediator, the two parties are together in a different format if the lawyers are not involved. It tends sometimes to open channels of communication that haven't been there, and there are opportunities for healing and reconciliation and moving forward, and that does periodically happen. Now, if there are issues in the course of the case that come up that are dramatic, where there's some clear indicators that we've got problems in relationships, courts can compel people on a limited basis to have an assessment and to see if there is a need, especially when it comes to dealing with the children, whether or not the children should go to counseling to understand the concept of what's happening to their family at the time, and parties as well, but on a very limited basis. Typically, most people are competent, they understand who they are, what they're doing, why they're there. It's difficult to have jurisdiction over them, just to compel them to go see a therapist. However, if they are clearly having issues in managing and coping with the process, then the court can make recommendations to do that.
Well, along those lines, let's talk about the virtues of being a judge in terms of how important is it to you to help bring families together, to help keep families together where you can?
Well, it's rather significant for me. I'm a family man. I have young children. I couldn't imagine being in a situation where we are not together as a family, and I've seen that over and over again in my practice over the years with young families, and the tragedy, so to speak, of separating. And I understand in some circumstances it may be for the best for the individuals, and sometimes it's in the best interest of the children if you have a relationship that's truly detrimental and it's causing harm to them. And so there are circumstances where divorce is definitely the best course, especially when there's physical abuse or verbal and mental abuse by one spouse or one party against either the children or the other spouse. So in those instances, it's clear that they need to get away, and they need to be saved, and they need to be protected. So that's why we have personal protection orders as well, which is something that happens in this court as well. But what I would say is it's important to me because the hundreds of families that I've helped over the years, whether it is in that format where divorce is necessary or appropriate, or whether or not it's a meeting with the client where I never have charged them, and I sat down with them and talked to them for an hour and pointed out what divorce really means to them, and hopefully never see them again when they leave my office. So as a judge, what I want to do, making sure that I'm still in that same vein, protecting families, make sure that the lawyers that are representing the clients that are coming in front of me, their clients, that they have a similar mindset, that the idea is to really help these people, and that if they're not, that we help guide them in the right direction to do that. So if there are opportunities for them for reconciliation, that they're exploring that, and not just for the sake of a fee, just pushing the case forward. I've had a number of cases in my career as an attorney where they reconciled, and it was one of the best things in the world because it was a great result. That's the best result in my mind, because families are the lifeblood of our community. If we don't have a solid foundation of families that are cohesive and want to be together, then our community starts to crumble.
Well, that's a great point. And, along with the problems and challenges that face young couples, and maybe even, older couples, there's emotional issues and personality issues, but oftentimes there's financial problems that lead to difficulties in a marriage. And do you, in your practice, and as well as even pursuing being a judge, how important is it for people to recognize that there's a financial cost and a lot of things at risk when you go into a court proceeding?
Absolutely. As an attorney, I lay that out right up front and let the clients know this is what you're going to have to pay up front, and here's what's going to happen going forward. And so that generally turns the light bulb on that, okay, there's a definite cost here, but also there's a spousal support formula, a child support formula that we use through the state court administrator's office. Essentially, you can run a prognostication, and the front of the court does that. The front of the court will give a prognostication for what child support is, and that becomes part of that first conciliation conference based on how many days each party has their child or children. Here's what the formula is. Here's what the formula is for medical, for daycare, for overall support, and if one spouse is the primary breadwinner, so to speak, then there can be spousal support temporary in the process of the divorce, and here's what your number is. And when you run a prognostication like that for somebody, it can be a real eye-opener. And your primary motivation, if it's financial for being a divorce, you probably have bigger problems, because if you do, that might mean that one spouse has other issues and has money issues. And if that's the case, it's usually because of some other reason, gambling or a spending problem, or just the fact that someone refuses to participate in helping earn an income for the family. So those are bigger underlying issues, but the financial aspect becomes the apparent primary issue because they are arguing over money.
Well, and as a follow-up with that, we've seen articles in the paper, and I'm sure things have come before the court. How important is it to make sure that people follow through on the arrangements that are made, because people must end up coming back into court because they're not complying with the terms of the settlement?
That's a great point, Kim, and it happens quite a bit. There are a number of times in my career as an attorney where we've gone back to court to modify support because either a change in circumstances, there's a job loss, a lower income, or a substantial increase in income of a party, and based on that, there can be specific reasons why you look back at the formula and you can adjust up or down. And the biggest problem that I see the most of is you have people that lose their job and they don't go to court and they don't modify the support because they've lost their job. And unfortunately, spousal support or child support continues to accrue, and they don't change that, and they get behind. And once there's an arrearage, you can't really go back and undo it. It's been accrued. So the problem is you get this ongoing accrual, you don't do anything about it, and the next thing you know, you get to a point where, and on child support, where you're now going to have a visit. Eventually, the prosecutor is going to look at a felony failure to pay child support, and you might get a visit from the police. There might be a warrant issued. And if you get a warrant issued for you for felony failure to pay child support, the biggest problem you're going to have then is now you're facing criminal charges, and in the meantime, it's still continuing to accrue. And there are people that don't deal with it, and they put their head in the sand. And as a lawyer and as a judge, hopefully, what I hope to do is make sure that people are just aware when they leave my courtroom. If I'm the judge, I want them to know these are what your obligations are. If you are unable to meet them, then you need to come back and talk to a friend of the court immediately, so that they know that and they're aware that they have to come back if there's a change in circumstances. They need to do that right away. And the saddest thing in the world is to see somebody who, because they've lost their job, and they just, by lack of caring or just ignorance, do nothing, and they end up now facing criminal charges, and that shouldn't happen. And it's sad because they should meet their obligation in the first place, and they should be doing everything they can because they love their children. And the viewpoint can be sour depending on how the divorce proceeds. But the bottom line is that child support is for the benefit of the child. So if they're not paying because they don't want to, or they're not paying because they lost their job, the bottom line is they should still be doing everything they can to pay. Now, if they need to reduce that, That's their obligation to come back to court to do it. But it's very sad as a member of this community to see that happen repeatedly, where there are men and women who don't want to pay because they think it's benefiting their ex. And it really isn't. It's really for the benefit of putting a roof over the head of the children, shoes on their feet, clothing to go to school, food in their belly. And it's bothersome to see that personal viewpoint, jaded viewpoint, but we see it repeatedly. And that's probably a big indicator of why they're divorced. Hello, my name is Joe Bush, candidate for Muskegon County Probate Court Judge. As a husband and a father, born and raised here in Muskegon County with strong family values, I pledge to work hard for everyone if elected as your next probate court judge. Probate court judges protect people who can't protect themselves. That's why we need a judge with compassion, integrity, and experience. I have over 20 years of trial experience in probate and family court, nearly 3 times that of my competitor. I've been endorsed by the entire probate court and 2/3 of the family court here in Muskegon County. The reason those judges have endorsed me is because they know that I have the integrity, compassion, and the experience that we need for this position. On November 8th, I ask you to flip your ballot over and vote for the most qualified candidate. Vote for Joe Bush for probate court judge. Thank you.
For the position of judge, we need a person who makes decisions based on reason and common sense. That's why I am voting for Jeffrey Nolan for District Court Judge.
Growing up Latina, I know all about being judged. I also know all about Jeff Nolan. That's why I'm voting for Jeff Nolan for District Court Judge.
When I enter a voting booth and cast my vote for judge, I want someone I know will be fair and impartial, and I want to be certain. That's why I'm voting for Jeffrey Nolan for District Court Judge.
I'm Jeffrey Nolan, and I approve this message.
Hello, my name is Joe Bush, and I'm a candidate for Muskegon Probate Court Judge. As a husband and a father, born and raised with strong family values here in Muskegon County, I pledge to work hard for everyone if I'm elected. Probate judges protect individuals and families who are unable to protect themselves. That's why we need a judge with compassion, integrity, and experience. I have over 20 years of trial experience in family and probate courts, nearly 3 times that of my competitor. I've also been endorsed by the entire probate court and 2/3 of the sitting family court right now, and I'm the only candidate endorsed by the judges. And the reason the judges have endorsed me is because they know I have the compassion, integrity, and experience for this important position. All jobs are important. This job requires someone who's qualified. On November 8th, I ask you to turn your ballot over and vote for the most qualified candidate. Vote for Joe Bush. Thank you.
Hi, I'm Terry Sabo. I'm currently the chairman of the Muskegon County Board of Commissioners and also a 25-year veteran of the City of Muskegon Heights Police and Fire Departments. Prior to that, I was on the Muskegon County Road Commission for 2 years and a veteran of the United States Air Force. I've spent a career on bringing people together to solve problems, and I intend to take that attitude to Lansing with me when I'm elected as your next state representative. I hope to earn your vote as the next state representative for the 92nd District.